In the modern era of capital punishment, beginning in 1976, 22 individuals were judicially executed by the United States for crimes they committed before their 18th birthday. Their cases marked the terminal phase of a legal tradition stretching back to English common law, where children as young as 7 could be deemed culpable of capital crimes. The final such execution was carried out in 2003, just 2 years before the Supreme Court declared the practice unconstitutional. The legal architecture governing the execution of minors in the United States was imported directly from English common law. This tradition held a bifurcated view of juvenile culpability, establishing the age of 7 as the threshold below which a child was considered Doli Incapax, or incapable of forming criminal intent. For children between the ages of 7 and 14, a rebuttable presumption of incapacity existed, a legal safeguard that could be overcome by prosecutorial evidence, demonstrating the youth possessed sufficient maturity to understand the wrongful nature of their actions. Beyond the age of 14, an adolescent was treated as an adult under the law, fully liable for criminal acts and subject to the same punishments, including death. This framework crossed the Atlantic, embedding itself in the legal codes of the American colonies, where records document the execution of individuals for offenses committed in their teenage years. For centuries, this standard remained largely unexamined by the nation's highest court. The constitutional scrutiny of capital punishment itself only began in the latter half of the 20th century, and the specific question of its application to juveniles was not addressed by the U.S. Supreme Court until 1988. The legal debate was framed by the Eighth Amendment's prohibition of cruel and unusual punishments, a standard the court had determined was not static, but must draw its meaning from the evolving standards of decency that marked the progress of a maturing society. The central question became how to measure that evolution. The first significant test was the case of Thompson v. Oklahoma. William Wayne Thompson was 15 years old at the time he participated in a capital offense. The court was asked to determine whether the execution of a person for a crime committed at that age constituted a constitutional violation. In a plurality decision, the court concluded that it did. The justices surveyed state statutes and found a broad societal consensus against the execution of offenders under 16, noting the infrequency with which prosecutors sought or juries imposed the death penalty in such cases. However, the ruling lacked a clear majority. Justice O'Connor, concurring in the judgment, provided the crucial fifth vote, but on narrower grounds, arguing that Oklahoma's failure to explicitly set any minimum age for capital punishment rendered Thompson's sentence unconstitutional. The decision thus barred the execution of 15-year-olds, but left the constitutional status of older adolescents unresolved. 1 year later, the court confronted that unresolved issue directly in Stanford v. Kentucky. The case involved Kevin Stanford, who was 17 at the time of his offense. The court's task was to decide if a national consensus existed against the execution of offenders aged 16 or 17. Writing for the majority, Justice Scalia announced that no such consensus could be found. The opinion detailed a statistical analysis of state laws, concluding that a sufficient number of jurisdictions permitted the practice to preclude a finding that it was cruel and unusual. The majority opinion further noted that the practices of other nations and the views of professional organizations were not germane to the interpretation of the Eighth Amendment. The dissent argued that the court had misread the evidence of a developing standard and had abdicated its duty to bring its own judgment to bear on the question. With the Stanford decision, the constitutional line was fixed. For the remainder of the 20th century, it was settled law that an individual who committed a capital crime at the age of 16 or older could be subject to the ultimate penalty. On March 23, 1944, in the segregated mill town of Alkaloo, South Carolina, the bodies of Betty June Binnicker, age 11, and Mary Emma Thames, age 7, were discovered in a water-filled ditch. The girls had been reported missing the previous day after failing to return home. Autopsies determined the cause of death for both was blunt force trauma to the head, inflicted with a weapon identified in reports as a railroad spike. The ensuing investigation led law enforcement to George Stinney Jr., a 14-year-old African-American youth who, along with his younger sister, was among the last individuals to have seen the girls alive. According to official accounts, deputies took Stinney into custody and interrogated him alone, without the presence of his parents or legal counsel. Law enforcement officials later reported that Stinney had confessed to the murders. No written or signed confession was ever produced as evidence. Following this reported confession, his court-appointed defense attorney, a local tax commissioner, was assigned to the case. The trial was convened on April 24, 1944, 1 month after the crime. The proceeding, from jury selection to the rendering of a verdict, lasted approximately 2 hours. The prosecution's case was built entirely upon the testimony of the law enforcement officers who recounted Stinney's alleged confession. The defense attorney called no witnesses, presented no evidence, and conducted no cross-examination of the state's witnesses. The all-white, all-male jury deliberated for 10 minutes before returning a verdict of guilty. The presiding judge immediately sentenced George Stinney Jr. to death by electrocution. No appeal was filed on his behalf. 83 days after his conviction, on June 16, 1944, the sentence was carried out at the South Carolina State Penitentiary in Columbia. Due to his small stature, official records note that the execution apparatus had to be adjusted. At the time of his death, he was 14 years and 7 months old, the youngest person judicially executed in the United States in the 20th century. 70 years later, in 2014, the case was brought back before the South Carolina judiciary. In a proceeding for a writ of coram nobis, a legal measure to correct fundamental errors of fact, a circuit court judge reviewed the entirety of the 1944 case file. On December 17, 2014, Judge Carmen T. Mullen issued a ruling that vacated George Stinney Jr.'s conviction. The court's order concluded that the defendant had been deprived of due process, citing multiple constitutional violations. These included the inadequacy of his legal representation, which the court found to be tantamount to no representation at all, and the coercive nature of the unrecorded confession, obtained from a minor without counsel or parental advisement. The ruling declared the 1944 trial fundamentally unfair and, as such, a failure of constitutional justice. In 1993, Christopher Simmons, age 17, was tried and convicted in Missouri for a capital offense. At trial, the prosecution introduced evidence that Simmons had premeditated the crime, telling his friends that his age would allow him to get away with it. The jury recommended a sentence of death, which the trial court imposed. For nearly a decade, the sentence stood. Simmons' direct appeals and post-conviction relief petitions were systematically denied by state and federal courts, all bound by the precedent set in Stanford v. Kentucky, which affirmed the constitutionality of capital punishment for offenders aged 16 and 17. The legal framework appeared immutable. The landscape shifted in 2002. In Atkins v. Virginia, the U.S. Supreme Court ruled that the execution of intellectually disabled individuals violated the Eighth Amendment. The court's reasoning was twofold. It identified a growing national consensus against the practice, and it determined that such offenders, due to their diminished capacities, were categorically less culpable and less subject to the deterrent purposes of capital punishment. This decision provided a new legal template. Simmons' attorneys filed a new petition in the Missouri Supreme Court, arguing that the logic of Atkins should be extended to juvenile offenders and that a similar national consensus against their execution had solidified in the years since the Stanford ruling. The Missouri Supreme Court agreed, setting aside Simmons' death sentence and holding that evolving standards of decency now precluded the execution of a juvenile offender. The state of Missouri, through Donald P. Roper, the superintendent of the correctional center where Simmons was held, appealed the decision. The case of Roper v. Simmons arrived at the U.S. Supreme Court in 2004. compelling the justices to directly reconsider their 1989 holding in Stanford. During oral arguments, the state contended that Stanford remained sound law. Counsel for Missouri, Donald Ayer, argued that the legislative landscape had not changed sufficiently to demonstrate a new national consensus, and that the court should adhere to the principle of stare decisis by leaving the precedent intact. The state's position was that any reevaluation of the juvenile death penalty was a matter for state legislatures, not the federal judiciary. In response, counsel for Simmons argued that the evolving standards benchmark had been met. They presented data showing a consistent trend among states toward abolition of the practice, either through legislation or judicial action. This argument was supported by a series of influential amicus curiae briefs filed by organizations such as the American Medical Association and the American Psychological Association. These briefs introduced a body of scientific and sociological research on adolescent development, including magnetic resonance imaging studies of the brain. The data indicated that the prefrontal cortex, the region responsible for impulse control, long-term planning, and risk assessment, is not fully mature in adolescence. This scientific evidence was presented to support the legal argument that juveniles, as a class, are less culpable than adults due to their transient immaturity and heightened susceptibility to external pressures. The argument was also made that the overwhelming international consensus, which almost universally condemned the practice, should inform the court's interpretation of the Eighth Amendment. On March 1, 2005, the Supreme Court issued its decision. In a 5-4 opinion authored by Justice Anthony Kennedy, the court affirmed the judgment of the Missouri Supreme Court and explicitly overruled Stanford v. Kentucky. The majority found that a national consensus against the juvenile death penalty had indeed emerged since 1989. The opinion cited the number of states that had abolished the practice and the infrequency of its application as objective indicators of this societal evolution. Crucially, the court's analysis went beyond the legislative tally. It embraced the argument regarding diminished culpability, identifying 3 general differences between juveniles and adults: a lack of maturity and an underdeveloped sense of responsibility, a greater vulnerability to negative influences, and a more transitory, less fixed character. These differences, the opinion stated, render the retributive and deterrent justifications for the death penalty less applicable to juvenile offenders. The court's reasoning, grounded in the inherent distinctions between youth and adulthood, established a categorical bar against the death penalty, but left unaddressed how this logic might apply to other severe, non-capital sentences. Finally, the majority opinion acknowledged the international consensus as relevant confirmation of its own conclusion. The court declared that the 8th and 14th Amendments forbid the imposition of the death penalty on offenders who were under the age of 18 when their crimes were committed. Wrongful in Roper v. Simmons had an immediate and definitive effect. On the day the decision was announced, 72 individuals were incarcerated on death rows across 12 states for crimes they had committed as juveniles. The court's order rendered each of these death sentences unconstitutional. The procedural remedy was commutation. State authorities were required to resentence each affected individual to the next most severe punishment available under the relevant state law, which in nearly all cases was life imprisonment. The sentences were altered through administrative and judicial orders, formally removing these individuals from death row and reclassifying their terms of confinement. Among those whose sentences were invalidated was Lee Boyd Malvo. In 2002, at the age of 17, Malvo participated in a series of coordinated sniper attacks across the Washington, D.C. metropolitan area. He was subsequently arrested and faced multiple capital murder charges in Virginia and Maryland. In 2003, a Virginia jury convicted Malvo, but deadlocked on the question of a death sentence, resulting in a mandatory sentence of life imprisonment without the possibility of parole. In a separate trial in 2004 for a different murder, another Virginia jury convicted Malvo and recommended a sentence of death. It was this capital sentence that was directly vacated by the Roper decision in 2005. His sentence was formally commuted to a second term of life without parole. The abolition of the juvenile death penalty, however, did not terminate the constitutional debate over severe punishments for young offenders. Instead, it shifted the legal battleground. The core reasoning of Roper, that juveniles are categorically less culpable due to their immaturity and capacity for change, provided the foundation for subsequent legal challenges to the next most severe sentence, mandatory life without parole. The Supreme Court first addressed this new question in Graham v. Florida, 2010. The case concerned a juvenile offender convicted of a non-homicide offense and sentenced to life without parole. The court ruled that such a sentence was unconstitutional, holding that the Eighth Amendment required that these offenders be given a meaningful opportunity to obtain release based on demonstrated maturity and rehabilitation. 2 years later, in Miller v. Alabama, 2012, the court extended this logic. It ruled that mandatory life without parole sentences for juvenile homicide offenders were also unconstitutional. The Miller decision did not foreclose the possibility of a life without parole sentence for a juvenile, but it required that the sentencing court first conduct an individualized hearing to consider the defendant's youth and its attendant characteristics before such a sentence could be imposed. These rulings created a new avenue of appeal for Lee Boyd Malvo. His life sentences in Virginia had been imposed mandatorily without the individualized consideration now required by Miller. In 2017, the U.S. Court of Appeals for the Fourth Circuit ruled in Malvo's favor, finding that his sentences were unconstitutional under the Miller precedent and ordering new sentencing hearings for him in Virginia. The state of Virginia appealed this decision, and the U.S. Supreme Court agreed to hear the case, titled Mathena v. Malvo. However, before the court could issue a ruling, the Commonwealth of Virginia enacted new legislation in 2020 that made all juvenile offenders, including those sentenced to life, eligible for parole after serving 20 years. Because this new state law rendered Malvo eligible for future parole, the Supreme Court declared the case moot and dismissed it without issuing a merits decision on the retroactivity of Miller in his specific circumstance. The procedural journey of his sentences had concluded, transformed by a decade and a half of evolving constitutional interpretation. Prior to the Roper v. Simmons decision, the United States was an outlier in the international community regarding its policy on juvenile capital punishment. The practice had been almost universally repudiated, both in law and in practice, by the nations of the world. This global consensus was codified in several major international human rights treaties. Article 37A of the United Nations Convention on the Rights of the Child, CRC, adopted in 1989, explicitly states, "Neither capital punishment nor life imprisonment without possibility of release shall be imposed for offenses committed by persons below 18 years of age." The CRC is one of the most widely ratified treaties in history. At the time of the Roper decision, every member state of the United Nations had ratified it, except for the United States and Somalia. Similarly, Article 6.5 of the International Covenant on Civil and Political Rights, ICCPR, adopted by the UN General Assembly in 1966, dictates that the sentence of death shall not be imposed for crimes committed by persons below 18 years of age. The United States ratified the ICCPR in 1992, but it did so with a specific reservation to this article. A reservation is a unilateral declaration made by a state upon signing or ratifying a treaty, purporting to exclude or modify the legal effect of certain provisions of the treaty in their application to that state. The U.S. reservation to Article 6.5 formally declared that the nation reserved the right to impose capital punishment on persons for crimes committed under the age of 18. This official act carved out a legal exception for the United States, allowing it to remain in formal compliance with the treaty while continuing a practice the treaty was designed to prohibit. The American Convention on Human Rights and the African Charter on the Rights and Welfare of the Child contain similar prohibitions, solidifying the juvenile death penalty status as a violation of established international legal norms. The majority opinion in Roper v. Simmons acknowledged this overwhelming international judgment, citing it not as a binding legal constraint, but as confirmation of the court's own conclusion that American standards of decency had evolved. Justice Kennedy wrote that the overwhelming weight of international opinion against the juvenile death penalty does provide respected and significant confirmation for our own conclusions. This use of foreign and international law in constitutional interpretation, while not dispositive, represented a point of significant contention in the case, drawing a sharp dissent from justices who argued that such sources were irrelevant to the meaning of the U.S. Constitution. At the time the Supreme Court was deliberating the Simmons case, only a small number of countries were known to have recently executed juvenile offenders. According to data compiled by human rights monitoring organizations, from 1990 until the Roper decision in 2005, documented executions of juvenile offenders had occurred in Iran, Pakistan, Yemen, Nigeria, Saudi Arabia, China, the Democratic Republic of Congo, and the United States. Following the 2005 ruling, the United States was removed from this list, further isolating the few nations that continued the practice. The legal and diplomatic position of the United States had shifted from one of explicit exception to one of constitutional prohibition, aligning its domestic law with the dominant global standard that had been in place for decades. In the modern era of American capital punishment, which commenced with the Supreme Court's decision in Gregg v. Georgia in 1976 and concluded for juveniles with Roper v. Simmons in 2005, a total of 22 individuals were executed for crimes committed when they were under the age of 18. The first was Charles Rumbaugh, executed by Texas in 1985 for an offense committed at age 17. The last was Scott Hayne, executed by Oklahoma in 2003, also for an offense committed at 17. The geographic distribution of these 22 executions was heavily concentrated. The state of Texas carried out 13, accounting for more than half of the national total. Virginia executed 3 individuals, Louisiana executed 2, and the states of Georgia, Missouri, Oklahoma, and South Carolina each executed 1. All of the executed individuals were male. A demographic analysis of the cases indicates that 11 of the individuals were white, 9 were black, and 2 were Hispanic. At the time of their offenses, 17 of the individuals were 17 years old, while 5 were 16. No one was executed for a crime committed at a younger age during this period. These 22 events represent the final statistical record of a practice that had endured in some form since the colonial era. The Roper decision did more than simply erase 72 names from the nation's death rows. It established a new constitutional principle grounded in the categorical differences between youth and adulthood. The court's reasoning that juveniles possess a diminished culpability and a greater capacity for change became a legal fulcrum. This principle, which had served to bar the ultimate penalty of death, was subsequently leveraged to challenge the finality of the next most severe sentence: life imprisonment without the possibility of parole. The legal frontier did not vanish, it relocated. The first test of this new frontier came in Graham v. Florida, 2010. The Supreme Court held that sentencing a juvenile offender to life without parole for a non-homicide crime violated the Eighth Amendment's prohibition on cruel and unusual punishment. The ruling established a categorical rule mandating that such offenders must be given a meaningful opportunity to obtain release. The court reasoned that a sentence with no possibility of parole was irreconcilable with the established principle that a juvenile's character is not permanently fixed. 2 years later, the court expanded this line of reasoning in Miller v. Alabama, 2012. This case concerned two 14-year-old offenders who had been sentenced to mandatory life without parole for homicide. The court ruled that mandatory life without parole sentences for juvenile offenders were unconstitutional. The decision did not create a categorical ban on life without parole for juveniles in homicide cases, but it forbade the automatic imposition of such a sentence. Instead, Miller required that before a life without parole sentence could be considered, a sentencing judge must hold an individualized hearing to take into account the mitigating qualities of youth, including the offender's age, maturity level, family environment, and the possibility of rehabilitation. Discontent. The Miller decision immediately raised a question of retroactivity. Did it apply to the more than 2,000 inmates already serving mandatory life without parole sentences for juvenile offenses? The Supreme Court answered this question in Montgomery v. Louisiana, 2016. The court declared that Miller had announced a new substantive constitutional rule, not merely a procedural one, and therefore must be applied retroactively. This holding compelled states across the country to begin the process of resentencing hundreds of individuals, some of whom had been incarcerated for decades. This series of rulings defined the legal landscape for over a decade, but the precise requirements of a Miller hearing remained a subject of litigation. The final evolution in this legal sequence came in Jones v. Mississippi, 2021. The court held that a sentencer is not required to make a separate factual finding that a juvenile offender is permanently incorrigible before imposing a sentence of life without parole. As long as the sentencing court had the discretion to impose a lesser sentence and conducted the individualized consideration required by Miller, the sentence was constitutionally permissible. The decision clarified the procedural requirements of a juvenile life without parole sentencing, but was viewed by dissenters as a retreat from the principles established in Miller and Montgomery. The abolition of the juvenile death penalty was not a legal conclusion, but a point of departure, initiating a new and continuing chapter in the judicial effort to define the constitutional limits of punishment for the young. We began this record with a final tally: 22 individuals, the last to be executed for juvenile crimes in a legal tradition stretching back centuries. Their cases mark the terminal point on a long, evolving timeline of American jurisprudence. But as we've documented, the closing of one legal chapter did not end the fundamental questions about youth, culpability, and finality. It simply opened another. Here at H Criminal Records, we trace these intricate legal pathways to understand how our standards of justice are defined and redefined. Landmark decision in Roper v. Simmons was pivotal, in part because the court's majority opinion cited scientific evidence on adolescent brain development. With that in mind, what are your thoughts on the role that evolving science should play when courts interpret constitutional principles that were written centuries ago? Thank you for joining us for this examination. We will open the next file soon, where we will document the complex aftermath of the Miller decision and the ongoing legal battles to define what constitutes a meaningful opportunity for release for those sentenced to life as children.